Hi, Devi. You're the first one to join back. Hi, Tvesha. I know it gets a little cumbersome to be, doing back and forth and everything, but we can't have breakout rooms in these webinars. So we had to shift to the meeting. Okay, everybody is joining us. 8 of us are here. I will start sharing my screen with you guys in the meanwhile and make sure that we are finishing what we started. Everybody can see my screen? Yes, in the chat box, please. Great, agree. Thank you. All right, awesome, perfect. So guys, we were here. We were about using the correct word and how important it is. Then we went on to the activity and we saw that we tried to paraphrase the prayer clause, and some of you, most of you could not paraphrase it properly. You repeated the entire sentence. I think at some level you thought that this is also important, this is also important, this should not be changed. So you did not make a lot of changes when you were paraphrasing the prayer clause. And then when some of you tried to paraphrase it and they wrote in the chat box like Imtiaz and Arjun, and I'm grateful to them that they wrote what they thought, so that they could be rectified and you could be told that this is not supposed to be done that way. Okay, so now we are going to move on to a very, very important topic. Paraphrasing is important, but also there are certain circumstances in your when you're reading your file and you're paraphrasing when you have to make a conscious decision to not paraphrase. Now, before paraphrasing, watch out for important points in the following annexures. So there are certain annexures, that certain documents that we support our submission, that we use to support our submissions. So like I said, okay, if it's a breach of contract, then, we'll attach the contract, that will become annexure. If we're talking about a particular circular or a specific legal provision or, any order, notification supporting judgments, contracts, anything else, okay? So we will make that our annexure. And if I'm saying to the judge, before the judge, if I say that as per clause number 3, the defendant was supposed to pay me an amount of so and so by such and such date. When I'm saying that to the judge, and the judge asks me, Imtiaz says, can you share this PPT? Imtiaz, I cannot share the PPT. I'm afraid because of, the IP rights and all. But don't worry, all of this is getting recorded, and I will be putting the recording on the, on your platform, the Learnist, where you access your modules. So you will be able to go back to the recording, and you can pause at a particular slide and try to understand what it means. So that will also be helpful. I hope you understand. Okay, so when I was saying, okay, so when the judge asks me, okay, so where is this particular clause? I cannot just open that particular page in my plaint and say, in para number 5, page number 7, in my plaint, I have mentioned this clause. And the judge will then ask me, counselor, are you the authority on this? Are you the one who has released this circular or this are you the one who is going to tell me that this is the most authentic document there is to check whether this clause actually exists or not? I will have to open the relevant page number, the relevant paragraph number from the main document that I'm talking about. If I'm referring to a clause of a contract, I'll have to open that contract on that page number, paragraph number. If I'm talking about a particular legal provision, I'll have to open the bare act and show where that legal provision is. I can't just say that it's written in my plaint or my written statement or whatever. If it's a particular government circular or notification that I'm referring to, I cannot say by opening my petition, my plaint, and saying that, okay, this is the paragraph, this is what the notification says. And the judge will be like, okay, so yeah, you are the government, right? You have passed the notification, and it's only what you are saying. On the basis of that, we're supposed to believe you. So the judge will never ever take anything on the face value. What you write in your submissions, in your plaint, in your written statement, even that is not considered to be the holier than thou word and everything, that that this is the main gospel of truth or something like that. Everything is questioned, and to prove that, you have your annexures. The annexures are the original copies of where you're taking those particular clauses from. So when you're referring to those specific legal provisions or those specific clauses, those specific supporting paragraphs from the supporting judgments, you do not paraphrase those things. Because like we just saw, when you paraphrase something, there are times when you may be using some different words and everything, and that may change the meaning of everything else. And that can work when you're making your submissions and general points, when you're talking about your rewording and rephrasing, and instead of one word you can use another word, and it'll still work in a way. It has to make sure that you have to make sure that the meaning doesn't change, but it will work. But when you're talking about a specific provision, a specific clause, a specific, especially the prayer, even if you have prayed for it, the judge will go through it very, very carefully, scrutinize every single word, and make sure if you deserve to get that relief or not. So even while paraphrasing that, you may make mistakes like we just saw. So do not paraphrase the prayer clause. Do not paraphrase the relevant clauses that you're referring to in your plain, in your written statement. If it's from a particular contract, if it's any particular paragraph from a judgment, do not paraphrase it. If it's any particular order or notification that you think is very important to be in your brief also, because the judge may ask you to recite it, you will have to recite it verbatim, word by word, it has to be the same. So you can read from your brief and you can recite it. Do not paraphrase it. Then any specific clause in section para. So the gist of the matter is, these are the situations when you don't have to paraphrase, when exact words of authority would lend support to your argument, when you want to state the law, when the original wording cannot be changed, and when it must be recited as is. So anticipate those situations, think about it, what kind of questions can be asked in this particular circumstance when you're raising this point, and then make a conscious decision when not to paraphrase. I hope it's clear, everybody. I'll also show you an example of how I paraphrased one of the paragraphs where a particular clause was mentioned, a particular legal provision was mentioned. So right, I'll show that example to you, but I'll just briefly check in on you on your assignment. So you've been given a PIL. I'm not going to discuss what the PIL is all about. For that, we have the feedback session, which will be the last session in the new year, actually. Yeah, it's going to be on 3rd January. So we're going to meet in the first week of the new year, and we're going to talk about your assignments and what you should have done and how you should have, prepared your brief. But this is something that you can ask yourselves. If you've already prepared your brief, you can ask yourself these questions. If you haven't, if you're still working on it, these are the questions that will help you streamline the whole code brief making process. So mind map, civil writ petition. A civil writ petition has been given to you in the form of a PIL. You can ask yourself, what is the stage of the case? What is the purpose of hearing? What are the important facts? What is the chronology of events? Then you can ask yourself, have you incorporated all the important points to make a persuasive case? Then what are the main arguments? What are the supporting documents? And what is the law on PIL? Of course, like we just discussed. Then what kind of brief would help? You have to figure out that you don't have to follow all the samples that we provided you. You don't have to make sure that it's in the tabular form and everything. And you just have to make sure that it's making sense, it's condensed, and you're not unnecessarily repeating things in your brief that have been repeated in the file. All the points are mentioned in a chronological sequential manner, but at the same time you're making sure that you're not repeating everything over and over again. You're not repeating the tables, you're not repeating the questions, you're not unnecessarily lengthening your brief. Imtiaz says, ma'am, what about issues when it involves the question of law? So usually in PIL, it does involve the question of law. It can also be a mixed question of law, in fact. So in those circumstances, what you have to do is you have to read what other courts have held in similar circumstances, what the Supreme Court has held in similar cases, what is the locus standi of filing a PIL, and then if you've approached the court, what is the major question of law that you're insinuating, that you're raising before the judge. You have to read it very, very carefully to understand that question of law, and basis that you have to make your arguments. So there is no framing of issues, there is no stage of evidence in Supreme Court. It's all about the facts that you're stating, what has happened, the main contention that you're raising. How has there been an infringement of a fundamental right? How has there been a major a major issue that involves the safety of the public, that involves the for the betterment of the public, that some steps should be taken. How is that? What exactly has been done that you say has been unfair, and how is it going to affect, and what can be done to remedy it? So you only raise your arguments basis that. Question of law then becomes whether or not this particular article or this particular section can be invoked in these particular circumstances. So can this law be applied to these facts? I hope it's clear now, Imtiaz. I will not discuss the PIL in any further detail. Now, before I go on to show you the example of how to paraphrase when you have a particular legal provision recited as is in your petition itself, I will show you that example. But before I do that, any other question, you can write in the chat box, raise your hand, write in the Q&A box. Imtiaz, please tell me if it's clear to you or if you need any more explanation on this. I feel like we keep losing people. Like, when we went from here to there, we were less. When we went from there to when we came back here, we are less. So I don't know, people get lost in while transporting from one medium to another, I guess. So, yeah, any questions, guys? Achin, Agrim, Devi, Dheeraj, Imtiaz, Madhuvanti, Sham, Sona, Tvesha. Okay, Imtiaz says, so we don't have to paraphrase the issues. Okay, you were talking about paraphrasing of issues. Okay, we can paraphrase the issues, of course. But issues are usually in the question form. So, like you saw in the sample that we've shared with you in the fourth module, when, there were certain issues, whether this has been done or not. And below that, we make our submissions, because so when there are issues, there will be OPP or OPD written. So OPP means onus of proof is on the plaintiff. OPD means onus of proof is on the defendant. And this is more, commonly, plaintiff is for civil cases and prosecution will be for criminal cases. So in that case, what we do is we write the issue, whether, let's say, whether there has been a breach of contract, or whether section 39 of Specific Performance Act will apply to this situation. This is an issue, and I am the plaintiff, and this is OPP. OPP matlab onus of proof. Onus of proof is on the plaintiff, so I will have the responsibility of proving this. So what I will do is I'll write the issue. Under that, I'll write the points which support me proving this. When I'm saying yes, it applies to the facts and circumstances of the case, I will show how by making my submissions under that issue. So I hope that helps. You write the issue. You can paraphrase the issue also. You can make the sentence shorter and simpler, and you can put it in the question form. And beneath that, you write your submissions in paraphrased form. So there will be arguments and submission throughout the plaintiff. You have to call out the important points. You have to make sure that if there are points that are being repeated in different paragraphs, you're writing that point once. And then in the bracket, you're writing the number of paragraphs that, this point has been stated in. Whatever you write in your brief has to be supported by the page and the paragraph number where it can be found. Also, do not forget to mention the relevant paragraph numbers and the page numbers of the annexures. Like I just said, certain clauses are important of annexures where you have to recite them as is. Even if I'm writing the same thing again in my, say, brief, Then I will say this is clause number 2, annexation number so and so, which can be found on page number this, and that's it. Okay. So make sure you're also mentioning the page and the paragraph numbers, which are important of annexures also. Any other questions, guys? Imtiaz, is that clear? You can write yes. Okay, awesome. So Achin says, ma'am, I know this is not relevant, but I was going through the e-court Saket and I saw there's CT case in list of cases dialog box. What is the full form of CT cases? Okay, so complaint cases are sometimes, they are abbreviated to CT. Now, this is also a little bit tricky, and this is something you'll realize as you go. Different courts also, they have case types, so they have different abbreviations for their kinds of cases, and they just write. So for example, CWP and SLP and FCS for ADJ and DJ, like we saw in the e-courts activity example that we did, the activity. So dheere dheere you'll make sense of all of this, although these abbreviations are not really mentioned anywhere per se, but there are certain links on certain official websites of the courts where they sometimes write the full forms of the case types also. So if you don't understand it, what you do is you open the order to that case. You open the previous orders, and you will, by reading the orders, you'll be able to make sense of what the case is all about. Okay, Agrim says, I'll ask on forum WhatsApp as I can't give full attention because of office, but thank you. Okay, Agrim, please do that. And thank you for being here despite office. I hope, I don't know if this is your internship or the job. Either way, I'm very happy for you. I'm very happy that you're working so hard and that, you got the opportunity that you wanted in these circumstances. It shows that all of us can do that. Okay. So, okay, okay, Arjun. Now, guys, before you leave, I have to show you the example that I was talking about. Okay, just to make it even more clear, I'll share with you. Now, I am assuming that you can see my screen. Yeah, this is the prayer clause that we just talked about. So this did not have to be paraphrased. The whole activity was to tell you that don't paraphrase it. If you're paraphrasing it, don't change the words. And a lot of things, like there has been a violation of articles 19, 21, 22. So you can, if you want to paraphrase it and you're absolutely sure you will not change the meaning of the prayer, then you can say that articles 19, 21, and 22 have been violated, and so as per clause 1, we are seeking release of we are seeking writ in the not in the nature, writ of habeas corpus. Then you can write dash, and then you can direct the respondents to release the detenus in annexure P2. Okay, and then you don't have to mention all of that, like team 3 was discussing, as these are the things that have already been mentioned in the submissions, and that can be made out from the prayer clause. So raids and details have already been mentioned, so just mention that habeas corpus, direct the respondents to release the detainees, then appoint warrant officers at state expense to visit the police station, jails of state in Haryana, and then where innocent farmers have been locked up and everything does not have to be repeated again. This does not have to be repeated again. Direct respondents to grant compensation to the persons illegally arrested, and then violation of Article 22 and everything. Okay. So pass any other. This does not have to be there. These things don't have to be there. That's why I didn't mention them in your question. Now, okay, so this is the paragraph that I have paraphrased for you. As per paragraph 6, it was written that none of the persons were arrested after observing the safeguards directed by D.K. Basu's case. Now, D.K. Basu case is a very important case which gave the guidelines of the arrest. So it's a landmark case. You can go through it. And given statutory recognition now. It's after D.K. Basu case, Section 50A in CRPC was introduced. So, just go through it when you can. The estimated numbers of illegally picked numbers by police are more than 200 people throughout the state, though the state can reveal the exact figures. Then the arrested persons had been sent to different jails, and even no information has been given to the relatives of the persons so arrested, which is mandatory in view of Article 22 of the Constitution of India and Section 50A of the CRPC, which is the Code of Criminal Procedure, which requires the person making arrest to inform about the arrest to the family members. Section 50A of the code is reproduced here and below for the perusal of this honorable court. Now, this section has been alleged to have been violated. So this section automatically becomes very important. Article 22 also says, the talks about the rights of the detainees and everything, and also the fundamental rights that we have. But that, more than that, this is more specific, and this is something that has been blatantly violated, which we are alleging in our petition. So it has been reproduced as is in the paragraph. So this is the section. So नीचे यहाँ पे लिखा है, however, none of the requirements were complied. No information whatsoever was provided. No one is aware that who has been arrested for what offense and where they are lodged. So this was the paragraph. Now, how I paraphrased it was, para 6, page 4. Police illegally picked up more than 200 people, approx. Instead of writing that, only the police know how many people they've arrested and everything, you just write approx. In violation of DK Vasu guidelines, Article 22 Constitution and Section 58 CRPC. Relatives do not know their whereabouts. Simple. Then I have reproduced the entire Section 50A over here in my brief. So if I'm asked, okay, what does the section say by the judge? Then I don't have to flip through the pages of my petition. I don't have to open the bare act. I just have to read from my brief, because this section is very important. It has been, specifically reproduced in my petition itself. So I have reproduced this verbatim in my brief. Okay, everybody. So that is it. Okay. Sham says, can you please share this PIL on the... Okay, Sham, what I will do is I will upload the PIL in one of the sections of your modules. I can do that, and you can go through the entire PIL. It's very interesting, actually. Okay, so I'll do that. Anybody else, any other questions? Is everything clear now? So you can make the requisite changes in your brief. You have tomorrow till midnight, like Cinderella. If you don't submit your assignments till midnight, then you don't get to be Cinderella anymore. Okay. Anyway, so any other questions before we end today's session? And after this, we will meet after the new year begins. So happy new year in advance, everybody. Thank you for sticking around, and Merry Christmas, and hope you're having a good time with the course, with the assignment, with your work, generally in life. And I know that, after your submissions tomorrow, you'll go into the holiday mode. I hope you do, because we need a break sometimes, guys. Everybody does. Madhuvanti says limit of 3 pages strictly to be adhered. Yes, Madhuvanti, because this is what we are trying to inculcate in you, that if your brief is too long, and especially if the PIL that has been given to you is 40-50 pages, or even if it goes on to 100 pages, and we make a brief of say 10 to 15 pages when the file is running into thousands of pages. So when it comes to 50-60 pages or 100 pages, then if you make a brief that is say 7 to 10 pages long, then we will be like, okay, so why not just read the file only? Why the brief? The purpose of the brief is to keep it brief, condensed. So yes, please try to stick to the 3 pages limit. Happy New Year, Tuesha. Thank you. Okay. Any other questions? If no, you can write no in the chat box. I'll end the session. Okay, great. Perfect. Agrim says, wishing you a very happy new year. Thank you. Have a good week. Thank you, Agrim. You too. Have a great weekend ahead. And thank you for being here, everybody. I hope things are quite clear. If you still have any doubts, you can always reach out to me. I'm always available. So all the best. Bye. And see you next year. Happy New Year. Bye.